In property management, there are certain conditions, rules, and regulations that should always be followed. These are called landlord-tenant laws. These laws essentially dictate how the landlord-tenant relationship should function. If you're not aware of your local or state landlord-tenant laws, keep watching. Hi, I'm Santiago Marino with DoorLoop. All right, let's get started. Let's start by going over what landlord-tenant laws are and why they're important. What are landlord-tenant laws? Landlord-tenant laws include the rights and obligations that each landlord and each tenant must follow. These can apply to those with rental properties, commercial properties, self-storage properties, and any other property that is managed by a landlord. In order to stay within the boundaries of these laws, both parties must know the basics of renting, like how to pay rent, collecting the security deposit, and much more. They must also be familiar with the basics of state and local laws regarding fair housing, discrimination, and the power of a written rental agreement. It's important to remember that these laws are important for the tenant as well. Landlord-tenant laws can also help tenants understand their safety rights, regulations on security deposits, written notices, and much more. They can also find information about the Tenant Act, which essentially provides them with extra protection and rights. For the landlord, these laws contain all the information about how they must respect tenant rights, how to evict tenants from the rental property, what can be done when a tenant fails to follow the lease agreement, and so much more. Now, although we cannot provide information on every single landlord-tenant law in this video, you can definitely find more information regarding your state by visiting DoorLoop's laws page. There's a link right there in the description. Make sure you check that out. All right, without further ado, let's go over the 10 most important landlord-tenant laws that everyone must follow. The top 10 most important landlord-tenant laws. Before we get started, I want to remind you that I am not an attorney, and I cannot give you any legal advice, financial advice, or medical advice, or basically any kind of advice. The one thing that I can tell you, or the one advice that I can give you, is that if you want to get access to a lot of valuable real estate content, you should definitely check out DoorLoop's resources page, okay? I'm going to leave a link right there for you in the description, all right? And another kind of advice that I can give you is to like and subscribe to our channel if you haven't done so already. You're going to get access to a lot of free real estate content, including templates, articles, videos, you name it. Discrimination laws. Discrimination laws are laws that protect tenants and landlords from anything that can be considered discriminatory. Many processes of the property management world can be considered discriminatory. These include things like advertising rental properties, screening tenants, or setting their rules in an apartment. When doing any of these things, it is very important for the landlord or property manager to make sure that they're in compliance with all fair housing laws. This means making sure that all actions and procedures are applied to everyone. And it means that nothing should be done that could possibly be construed as affecting only a portion of people. Even if the intent was not to discriminate, landlords can still be sued. And the worst part? Discrimination lawsuits can cost the landlord upwards of $50,000, not including a lawyer and court fees. So be sure to pay close attention to everything that is done within your business. Providing a safe environment. Next on the list is the landlord's responsibility to provide the tenant with a safe and habitable environment. This means that the rental unit cannot have any serious problems or safety hazards. It also means that all appliances should be in working order. All lighting fixtures, plumbing, and heating systems should also be in working order. Also, the entire property should be free of any insects or pests. The landlord can also specify in the lease agreement what each party is responsible for in terms of maintenance. This can vary by state, so it is very important to check with your state's specific laws. However, it is important to note that the landlord is not only responsible for the property's condition at move-in, but also throughout the entire tenancy. This is done through maintenance requests and work orders. The next item on our list will go over the laws on conducting maintenance and repairs on the property. Conducting repairs. There are also landlord-tenant laws that dictate how repairs and maintenance must be handled in rental properties. These laws affect both the landlord and the tenant. The tenant has a responsibility of reporting any repairs that need to be done that have been specified in the lease agreement. Then, the landlord has a responsibility of taking care of the issue in a quick and timely manner. If the landlord does not conduct the requested repairs, the tenant may even withhold rent money until it is finished. This is specifically relevant when the lack of repairs can possibly affect the health and well-being of the tenant. Security deposits. Next on the list are security deposit laws. These laws are important because most, if not all, lease agreements contain some clause on security deposits. However, it is important that every landlord consult with their local and state laws before adding security deposits to their agreements. These laws can dictate everything about security deposits. This includes how much can be collected, what can be done with it, and whether or not it has to be returned. Most laws state that the landlord should create an itemized list of any deductions from the security deposit. This allows the tenant to know exactly where their money went and what it was used for. Tenant abandonment. The next law on the list is regarding the event where a tenant abandons a rental property. Abandonment occurs after a tenant stops paying rent for a rental property and leaves personal belongings behind. In this case, it is important that the landlord is careful with what they do. The landlord is responsible for notifying the tenant about how to claim the property, the cost of storing their items, and how long they have before the property is reoccupied. Your local and state laws can determine what to do with the tenant's personal belongings. This could be either staying with the property or selling the property at a public sale. Legal lease documents. Although this may be self-explanatory, it is the landlord's duty to provide the legal paperwork for a rental property. Usually in the form of a lease agreement, it is the landlord's responsibility to include things like leasing periods, monthly rental rates, and tenant names. Your local and state laws can provide more information regarding what information must be included. It can also determine what specific clauses and legal disclosures must be included. Legal disclosures. As mentioned before, many states require landlords to provide certain legal disclosures before the tenant even moves in. These disclosures can include important state laws, individual landlord policies, or rules about the rental unit. Many states have different requirements on what the landlord must disclose to the tenant. The landlord is typically responsible for disclosing information about mold, recent deaths, sex offenders, lead-based paint, meth contamination, or any other safety hazard. Privacy. Next on the list is the tenant's right to privacy. It is also referred to as the tenant's right to quiet enjoyment. What this means is that the tenant has a right to live on the property without being disturbed. This comes into play once the tenant moves in, meaning once the tenant takes possession of the property, the landlord cannot interfere. Because of this, the landlord must provide proper notice before they enter the property, especially if it is for an inspection. Criminal activity. If the landlord becomes aware of any illegal activity taking place within one of their rental properties, it is their responsibility to report it to the authorities. This activity could include drug use, drug distribution, domestic violence, or much worse. If a landlord does not report the illegal activity occurring in their rental property, they can face significant legal punishments. So, for this reason, it is important to make sure that everything is always reported. Safety measures. Last on our list of the most important landlord-tenant laws are laws regarding the safety features of the rental unit. This means providing information about any smoke detectors, carbon monoxide detectors, fire extinguishers, and much more. This also varies depending on your state, so it is very important to review your state-specific laws. Okay, so let's wrap it up. It is obvious that following all landlord-tenant laws is something extremely important. If any of the parties fails to follow these laws, they could face significant legal consequences. Also, since these laws are continuously changing, it is important to repeatedly check the most recent laws to make sure that you are up to date. Okay, so that's it for now. Remember, if you want to get access to a lot more content and resources, free resources, including templates, articles, videos, everything on real estate, make sure you click on that link down there with DoorLoop's resources, all right? And then you'll be able to find all of that. And if you haven't done so already, go ahead and like and subscribe to our channel. And we'll see you in the next video. And as always, happy renting.